You've all heard the police on TV reading someone their rights. They're called the Miranda Rights for a famous United States Supreme Court decision. If you're like most people, you can recite those rights in sync with the officer. But what do those rights really mean, and when do they actually apply? The Miranda decision actually provides more than one right to a person under arrest. Let's break down the Miranda rights one at a time. 1, you have the right to remain silent. So that means if I don't say anything, they have to stop questioning me?
No, Kate, actually, you must assert your right by talking out loud if you want to have a right to silence. This means you must clearly state you're not going to answer any questions and then stay silent. If you don't do that verbally, the officer may continue to question you. Also, if you choose silence but then occasionally interject information when you disagree with the officer, you may have waived your right by breaking your silence. Police then have a green light to ask additional questions of you. If you wish to provide simple information such as your name or your address, do so, but then reassert your wish to remain silent. Keep in mind, however, that police generally have this information and also much more information about you in the case they're investigating. Further, they have no duty to share their information with you. Now, the second right says anything you say can and will be used against you in a court of law. Does that mean if I don't say anything, the prosecutor can say I was trying to hide the truth?
No. It is your constitutional right to be silent, and your silence cannot be used against you. This means the prosecutor cannot tell the jury that you refuse to speak to the police. The prosecutor cannot tell the jury that your silence must mean you're hiding something. The prosecutor cannot comment on your choice to remain silent in any way at a trial. However, if you do choose to speak with officers, absolutely everything you say can be used against you in court. This means comments made under your breath, to someone else in the room, or in response to a question that doesn't seem to apply to the current situation at all. Even harmless sounding questions about your background, your family, your job, or what you had for lunch are likely to be asked for a specific reason. This can lead to a conversation you never intended to have or providing information you never intended to give. Anything you say will be compared to other statements and evidence. Even small differences between what you say and other evidence can be used to attack your credibility. Simple mistakes of memory can be painted as attempted dishonesty on your part. Remember, if you choose to be silent, stay silent. But what if I haven't done anything and want to tell that to the officer?
That leads us to the next Miranda warning. You have the right to consult with an attorney before questioning and to have a lawyer present with you during questioning. This means what it says. You have a legal right to have a lawyer present with you before you answer any questions. You should assert your rights in a calm, polite manner, but one that leaves no confusion. Say it and mean it. Tell the officer, I'm happy to cooperate with you, but before I answer any questions at all, I need my attorney to be here with me. Keep in mind that depending upon the time of day or the week, your lawyer may not be immediately available. If legal counsel isn't immediately available, you may be held while law enforcement decides whether or not to place you under arrest. If arrested, you could be held in custody until you can post bail or you can appear before a judge for a bail or a bond hearing. During that time, maintain your silence, and if approached again by law enforcement, reiterate your refusal to answer questions without your lawyer present. But what if I'm under arrest and I don't have my own attorney or I can't afford one?
That's a good question, Tim. Miranda states, if you cannot afford to hire a lawyer, one will be appointed to represent you at public expense before or during any questioning if you so wish. This means that if you do not have the financial ability to hire your own lawyer, there will be a lawyer from the public defender's office appointed to help you. Even if you don't qualify for a public defender, if you are in custody, a public defender will be available for a bail hearing in front of the judge. Until that lawyer meets with you, the police cannot question you if you have asserted your right to silence. Even the judge at the bail hearing cannot ask you questions about your case. The judge will only ask questions related to your identification and ability to understand court proceedings. The last portion of the Miranda warning says, if you decide to answer questions now without a lawyer present, you have the right to stop the questioning and remain silent at any time you wish, and the right to ask for and have a lawyer at any time you wish, including during questioning.
We recognize people sometimes begin speaking to the police because it appears to be a friendly and unthreatening situation. As questioning occurs, you might sense you are the target of the investigation. Even if you begin to answer questions, you can assert your right to silence and to have an attorney present at any time. Just as before, be calm, be respectful, but also be clear and firm. If you have to wait for a lawyer, sit tight and stay quiet. Don't speak up. That could accidentally waive your rights. Don't make the mistake of venting in a phone call to family or to a cellmate at jail. You don't know who is listening or who could benefit from incriminating you. Are we saying you should never speak to a police officer? No. While police officers are trained to obtain as much information as quickly as possible, they are also trained to uphold your rights if you properly assert them. They will not punish you for asserting those rights. Remember, even if you've done nothing wrong, it's still safer to give any statement with your attorney present.